Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today may be the day I earn your subscription. For today's live stream, we are going to be covering the brief that was filed by the women's national team in the ongoing lawsuit of the women's team versus the U.S. State Soccer Federation. So, as we all know, the district court found that the women's team was paid fairly. They ruled this because the women's team was offered the same deal as the men, and they declined. They declined the deal for fairly pragmatic reasons. They wanted guaranteed pay and benefits that the men were not being offered. The men were being offered straight cash. Pay for play. That's all. You pay when they play. You don't play, you don't get any money. The women wanted $100,000 guaranteed salaries and benefits and so forth and so on. And even in retrospect, it's not clear to my mind that they necessarily made a bad deal. In this past year, where COVID was in place, the men's team and men's players got zero because there were no games. So they got paid nothing. And the women's team also had no games, but they're on salary, remember? So they got all that stuff. So, it's not clear that they were any worse off. So it's a little bit weird because one would presume, therefore, if they're to be paid the men's deal, that the women's team would have to start writing checks for the things that they got that they're not supposed to, but whatever. Anyways, we're going to be reading their brief and we're going to be seeing if it has any legal merit to it. So let's get started with this. We are in the United States Court of Appeals for the Ninth Circuit. We are on appeal between Alex Morgan et al. And the United States Soccer Federation. And this is the opening brief for the plaintiffs. The women's team has thoughts and they want to share. Skip all the table of authorities, skip all those references. Okay, introduction. The U.S. women's national team is the best women's soccer team in the world and one of the best sport teams in history. The team has established the United States as a soccer powerhouse, at least among women, and has won the hearts of millions of fans around the world. I'm sure that's true. The team has also brought international acclaim and millions of dollars to the Soccer Federation. I'm sure that's also true. The organization that employs the men and women's teams. In the Federation's words, the members of the women's team are the best athletes in the world. I'm sure they said that. I'm sure that the leaders of pretty much any professional team would probably say that, because, yeah. Yet the Federation consistently paid them much less than members of the men's team, even though they're doing the same job, representing the United States International Soccer Games. Okay, the pay difference is huge. If the Federation had paid the women at the same rate as the men, the women would have made an additional $64 million over the 5-year period at issue in this case. Yeah, that's true, but again, they bargained for this because they wanted the guarantees. The men didn't get paid last year because there were no games. The women's got paid, even though there were no games. So yeah, they would have gotten $64 million more, but they wanted to trade the guarantee for security, which is a perfectly reasonable trade, and benefits members. So yeah, I'm not sure even in retrospect you can necessarily say it was a bad deal, but either way, you're able to make the deal. It was a perfectly valid, calculated consideration. So I think any of us might lucidly have made that deal. It's not like obviously in retrospect a bad deal, like that was inherently bad. It's like, no, given your various preferences, that makes total logical sense. It's a perfectly valid deal to make. You might make the same deal today, for that matter. The Federation's pay discrimination has been widely recognized. Sponsors of the national team and members of Congress, and I definitely value their opinion because it's not like they're mugging for political points, have expressed concern about the significant pay gap between women's and men's teams. The men's team, in part, has called out the Federation's discrimination and urged the Federation to pay women equally. And whatever. The Federation itself acknowledged the inequality. It just told women they do not deserve equal pay. After years of unequal pay, the member of the women's team sued the Federation. They brought their claims under the Equal Pay Act and Title VII, which prohibits discrimination on the basis of sex in employment. They explained that the players on the women's and men's team receive essentially two types of play. Right. Appearance fees for playing in games and performance bonuses for winning. And also, in the case of women's team, a salary. That's the difference between the women's and men's contract. Both get appearance fees for playing. Both get bonuses for winning. Only the women's team gets a guaranteed salary. So, yeah. The women point out in order to make the same amount as men over a 5-year period, they had to be the best in the world and obtain the highest performance bonuses available, while the men never ranked above 22 in the world. And the women show there's no good explanation for the pay disparity. Yes, there is. It's what you wanted, because you wanted the guarantee. The men got squat all last year. You got paid. The women are more successful than the men. They're more popular than the men. I'm not sure how we're quantifying that, but okay. And they bring in more revenue than the men. I think it's about 50-50. I think the women bring in slightly more, like 50.5% or something. The district court grants summary judgment to the Federation, holding the women's pay and men's pay was equal. Essentially, the court reached that surprising result by looking at total pay without accounting for the women's superior performance. Incidentally, in a prior interview, the women's team said explicitly that performance shouldn't be a factor. They said it explicitly. They said we should just be paid on play, not paid on performance. So again, something they have swapped their opinion on, I guess, because it's convenient. In effect, the court has held that if pay is equal, if a woman can obtain the same money as a man by working more and performing better, that is not the law. That's true. That's fair in the abstract. Right. In the abstract, that's fair. There's a reason it's not fair here. The men and women's team have different unions. They're allowed to have different preferences. The women's team should have been offered the same deal. By their own public statements, as we noted on Nate's channel earlier today, they were provided the same deal. They were offered the equal pay deal. Megan Rapinoe turned it down. So I guess you're saying that women shouldn't be free to make choices or something. I don't know. Okay. The court also treated the women's collective bargaining agreement as somehow weighing their equal pay rights, which is flatly wrong. When you specifically reject it, I'm not so sure. And discount the women's direct evidence of discrimination, which the court is not allowed to do in summary judgment. Sure they are, if it doesn't impact the legal argument. Right? We're interpreting this, you can disregard anything that's not legally apparent. Right? So you as a court, when you're considering judgment, you have to consider all the things that are relevant to the decision. So are the statements of discrimination relevant? Well, if those statements are relevant, presumably your statements that we were definitely offered equal pay and, for sure we wanted just to go on performance and not on bonuses would be equally admissible. But the court says, I'm just looking at this as a straight matter of law. You had the opportunity, you bargained for something else, for choices and preferences, and now you want to retroactively go better because in retrospect, apparently it would have worked out better for us. So, you wanted to moderate your risk. You took a conservative position, which is perfectly reasonable. The district court concluded that no reasonable jury could find the women were paid unequally. This is legally wrong and defies reality. This court should reverse and remand. Issue presented: whether the district court erred in granting summary judgment to the Federation equal pay claims under Title VII of the Civil Rights Act on the ground that they received equal pay as a matter of law. Okay. The relevant statutory authorities are ended in the addendum. Okay, here's some facts. I'm not sure why these facts are necessarily relevant, mind you, because when we're looking for facts that matter, we're looking for facts that impact the legal analysis, right? We're looking for facts that impact the legal analysis. So saying the women's team is super duper successful and they're loved and all is legally irrelevant. It doesn't matter. We don't care. But let's talk about it anyway, even though it has no legal impact. But okay. Plaintiffs are current and former members of the team. The players are professional athletes who represent the United States in international women's soccer games and also won't stand for the Pledge of Allegiance and also hate our flag and so forth and so on. But they'll still represent the United States. But okay. The women's team is the most successful team in international soccer history and one of the most dominant squads in the history of the sport, men or women. Okay. Since the team's inception in 1985 has never been ranked lower than second in the world by FIFA, its international governing board for soccer. One wonders what the competition from other countries necessarily looks like in the same time frame. The women's team has won the World Cup, the global competition, a record 4 times, and has won 4 Olympic gold medals. Not so much this year. In recognition of the success, the Olympic Committee's named the women's team Team of the Year four times, another record. Okay. From 2015 to 2019, the time period at issue, the women's team attained unprecedented success. The team was ranked first in the world that entire time and won both the 2015 and 2019 games. During the period, the team played 111 games and won 92 of them, drew 12, and lost only 7 for 6%. So they won or tied 94% of the time. So, not bad at all. The men's team was much less successful. It was ranked between 22nd and 32nd in the world, maybe because there's more competition for men, just guessing, and did not qualify for the World Cup. The men's team played fewer games and won 53, drew 18, lost 29. Their competition may be harder, just speculating. Thus, the women's team played more games and had much greater success than the women's team. Yeah, but you see, this is kind of part of the problem when you're trying to calculate equal pay for equal work, because if the women's, it's assuming the premise that the women's team has an easier time of winning because the competition is the first, they literally don't have to work as hard to win a game, right? The men have to work harder to win a game because they have worse competition. So that's another problem. It only is discrimination on the basis of sex if it's discrimination on the basis of sex. If the reality of it is such that, that's just reality, that's not discrimination on the basis of sex, that's reality. Driven by, if the women really want equal pay, they presumably, I at least, let me put it this way, I would support them playing in the men's field. We can have a special team for it. I'm sure FIFA will approve. We can have the women's team also competing in the men's competition. And they can have that, and then they'll be equal. Right? Okay. Driven by immense popularity of the women's team, interest in soccer has reached a historic high. I'm not sure if it's necessarily because of that, but yes, it has definitely gone more popular. And I think that's good because, we need to have more money in it so we can get better players, and the U.S. can, whip the rest of the world like it does in everything else. As Federation recognized, the women's team has inspired an entire country. The 2015 World Cup final in which women beat Japan was the most watched soccer game in U.S. history. The 2019 final was the second. The most watched soccer game. I just wanted to emphasize that point there. The Federation is the national governing body for soccer in the United States. It's tasked with developing the sport of soccer in the United States. In doing that, it's required to provide equal opportunity and not to discriminate on the basis of sex, which presumably they could do if they were so inclined by letting men and women try to compete for slots in the men's team. Equal opportunity, right? Feel free to come to tryouts. See if you can outperform the men. Equal opportunity. If you can do it, I'm sure they'll be more than happy to hire you. The Federation has exclusive authority to field teams to represent the United States in international soccer competition. Yeah. The Federation organizes both women's team and men's team. The Federation hires coaches and trainers, organizes the camps, and provides transportation, accommodations, and meals for games. Okay, incidentally, so I don't miss the issue, they also, part of their lawsuit was dealing with some of these ancillary or fringe benefits, and that part of the lawsuit has not been subject to summary judgment. So part of the lawsuit, that's still at the trial stage, is whether or not the women were discriminated in, for example, their transportation, the quality of their airplane rides, the quality of their hotels, logistics support, and so on and so forth. So that part of the thing is still going on. And, I think the women have a pretty plausible claim that, they're not being treated the same there. So, I think the women have a better case there because there's no particular reason why the men and women shouldn't have equal quality transportation. There's nothing about their performance that should necessarily imply what kind of planes they fly, or what kind of hotel rooms they have. So I think the women have a better cause of action. So that part of the case is still ongoing at the trial court level, so I didn't want to miss that. The Federation pays members of each team according to collective bargaining agreement, which is negotiated by each team union, which, I think is a point that bears some emphasis, which is negotiated by each team's union. It was already settled? I'll take your word for it. Either way, well, yeah, it wasn't, let me put it this way. It was still ongoing at the time that the appeal was filed. It may have been resolved since then. But yeah, maybe it's been resolved since then. So, okay, fine. Either way, it was still pending when this lawsuit was or the appeal was start going. The district court did not rule on that issue, or reach a conclusion, I should say. Players in the men's team are primarily paid for two things: playing and winning. Yeah. The Federation pays appearance fees and also fixed salary in the case of women. I suppose we're going to keep ignoring that fact because it's inconvenient, but yeah, I'll keep mentioning it. That is, the Federation pays the players appearance fees for playing in games and performance for winning. Yes, that's true, and there's also a third thing. The players are not paid solely for coming to work. They're paid more for each success they achieve. Yes, that's true, but there's something else. Also, which is very true, in last year, they were paid specifically even though they didn't come to work. They couldn't come to work because COVID, and they were still paid. So the players are not paid solely for coming to work. Yeah, that's true, because in the case of the women's team, they're also paid for not coming to work because they have a contractual guarantee. They have a guarantee. The Federation assumed that risk, and they benefited accordingly. So they got paid for not coming to work because it's part of the deal. The women's team and men's team play in games known as friendlies and in tournaments. Friendlies are games played against other national teams that are not part of a tournament. Tournaments include men and women's teams, cups, and various other tournaments, such as the She Believes Cup and men such as the Gold Cup. Incidentally, I think the She Believes Cup needs a rename. That's just... The Federation receives all revenues associated with teams, then it pays the players. Yeah. The revenues come from a variety of sources, including ticket sales, which can include friendlies and tournament prize money, sponsorships, merchandising, and broadcasting rights. Sure. For the first two categories, ticket sales and prize money, the women's team brought in greater revenue than the men's team during the time period at issue. The revenues were $94 million for the women and $72 million for the men. For the third, that sounds slightly off to my mind, so yeah, maybe I'm not sure about that one. But we'll take their word for it anyway. For the third and fourth category, sponsorship and broadcasting rights, the Federation earned about $50 million for each year, each team combined. Okay, yeah, so maybe that's why it would add out differently, because then you would effectively add $25 million to each team's revenue, because it'd be split evenly, and that's how you get a different calculation, right? So they're segregating out the joint funds where that was calculated in as part of the different analysis. Okay. The Federation revenues grew substantially in the last decade, netting the Federation's significant cash reserves, which is irrelevant. You know what matters? What matters is the contract. You can make a contract basically on anything. You can make a contract based on anything, especially this kind of contract, which involves what we might call sophisticated parties. So you can agree to pretty much anything. You could agree to split gross revenue. You could agree to guaranteed salary. You could agree to pay for play. You could agree to pay for performance. You could agree to a share of ticket sales. You could agree to a share of merchandising rights. You could agree to a share of broadcasting rights. You can agree to pretty much anything. So, what you agree to is what you agree to. So if your agreement does not include gross revenue, then the fact that the Soccer Federation has more gross revenue is irrelevant because it's not part of the contract. So it's just profit for the Federation because that's what the agreement is. See what I mean by it not being relevant? It doesn't matter. No one cares. Much of that growth was due to women's soccer success. Okay, speculative, but fine. The women's sponsors want to invest in the women's team specifically because it's popular consumers. Okay. Well, if your agreement had said something like, if investors want to invest with the women's team, we get a piece of that, that would have been great. Otherwise, I don't care. Do we know why the contracts were vastly different? Yeah, that seems to be what they negotiated for. The district court found they were offered a similar pay structure. And the women's team, at least and in Nate's clip, from earlier today, and you go to Nate the lawyer's channel on this, there's a clip with with one of the players saying, yeah, we were offered the same deal. We had, in 2016, we were so close. We had equal pay. It was ready to go. And then Meg and Rapinoe apparently decided to, turn it down. So the reason they're vastly different is because apparently the women wanted it that way. $5 from Ricardo Ospania. Thanks for the super chat. From what I understand, a CBA can allow otherwise illegal terms. Why a union pretending they don't have lawyers looking at these contracts? Yeah, probably. I mean, yeah. Although the Federation's mission is to grow the sport of soccer in the United States, the Federation has underinvested in the women's team from the very beginning. The Federation first refused to buy uniforms instead of requiring the players to wear hand-me-downs from the men's team. I would want to know what the contract says, but even if it allows for it, that's a bit of a dick move. Buy the players' uniforms. I mean, even if you don't have to, just do it. Then the Federation provided the women's teams with less training and fewer doctors and physical therapists when the team traveled in games. Well, one might inquire if there are fewer doctors and physical therapists because maybe the women aren't getting into as many injuries as the men, because the men's game is more violent, more aggressive. So maybe they don't need as many doctors and many therapists. I mean, I'm just guessing as to training. Maybe they need less training because they're already great. So they don't need as much training as the men's team because the men's teams needs help. I mean, those are valid reasons, right? It seems to me. Then the Federation provided the women's team with less training. Okay, we did cover that. The Federation also provided the women's team with worse travel arrangements, including lower quality accommodations and less comfortable flights. And as I mentioned earlier, that was a different part of the lawsuit, which apparently has been settled. And the Federation scheduled a higher percentage of the women's game on artificial turf, which carries a higher risk of injury than grass. One might wonder why. I wouldn't know for sure. Is it out of malice, or is there some reason that women's team play more on artificial grass? I don't know. I don't know much about how soccer is organized in the fields that choose, so don't know about that one. The Federation was also slow to promote women's game and seek merchandising opportunities. Maybe at the start, maybe they had other things on their mind. And unless the contract requires them to do that, once again, you can contract for anything. If you want them to have an obligation, contract for it. You're obligated to promote us. You're obligated to put out merchandising and so forth and so on. Negotiate it for it. For example, when announced games just a few days before kickout, too late to sell at stadiums. Here's the thing, maybe you could put in the contract. You're required to announce our games for these methodologies at least so many days in advance. The Federation also would schedule women's games in a smaller stadium, set lower ticket prices for men's games. I'm guessing that's because there wasn't as much popularity for the women's games and people didn't want to come. So they didn't need as big a venue. And if they charged more, fewer people would start up. I'm assuming they tried to charge the maximum price the market would bear. I'm just assuming that because it seems like a reasonable assumption. Because what happened? Did the Soccer Federation stop being greedy? Did they not want as much money as possible? Were they not charging as much as they thought they could get away with at the ticket counter? Did they forget being greedy? This is one of the things, I know this is a bit off point, but this is one of the things that I think that sometimes people who are talking about like minimum wage and stuff don't fully calculate. Because they'll say things like, and you'll forgive me, the numbers here are off point, but you'll get the idea. So they'll say things, well, if McDonald's was required to change the minimum wage from this to this rate to this rate, it would require McDonald's to only raise the cost of a Big Mac's by 11 cents in order to compensate for that. And then I'm always like, okay, but that assumes that McDonald's can raise the price by 11 cents and it would have no impact on sales. So then the question is, did McDonald's forget to be greedy? Why aren't they charging that 11 cents now? If they could charge that 11 cents and would have no impact on sales, why wouldn't they charge the 11 cents? Did they forget how to be greedy? Did they not want the 11 cents? Especially when you're talking about Big Macs and selling them over and over and over and over and over and over, and the 11 cents is going to turn out to be a whole shit ton of money. Did McDonald's forget how to be greedy? Yeah. Despite these obstacles during the time period at issue, the women's team more than made up the difference in revenues that used to separate the women's and men's team. Yeah. The lawsuit concerns the time period from 2015 to 2019. Under the collective bargaining agreements in effect during that time, the bulk of the players came from appearance fees and performance bonuses. And critically, although it might not be the bulk of the pay, it is a very important part of the pay, the guaranteed salary. The $100,000 may not be a lot of money in the context of these other sources of revenue, but it was guaranteed. So it can't exactly be treated the same as the other money. It's kind of important. For every appearance and performance bonus available to both teams, except one, the Federation paid women at a lower amount than it paid men. Because that's what the contracts presumably required. For example, for winning a friendly against a team ranked 10th in the world, the Federation paid each male player a bonus of $12,625, while paid each female player a bonus of $1,350, or $5,250. When the women won the 2015 World Cup, the Federation paid the teams $1.725 million in bonuses. You know, not for nothing, but it seems like if you're accepting the premise that the men's team brings in equal revenue to the women for working more hard, so the men have to work harder in some senses because their competition is stiffer. So you could debate about who has to work harder. The women's have to play more games, but the men might have to work harder because the competition is harder. So it's like, well, we want money, and it seems that men's games are more popular by attendance. So you want, and more popular by merchandising and more popular by everything else. So you essentially want the men to subsidize the women because their markets are not equal. You know, their revenue is not equal. One would think that, you know, they could get a similar structure, but to be paid exactly the same would presumably require one team to supplement the other team because they're not the only way that for that not to be true is everything is equal in terms of ticket sales, in terms of broadcasting, in terms of merchandise sales and something, right? So if everything is equal, then it doesn't matter. But if it's not equal, then one team is necessarily supplementing the other. Is that really fair? Is that what the Equal Pay Act had in mind? When the women won the World Cup, the Federation paid the teams $1.7 million in bonuses. When the men lost, they paid them $5.7 million in bonuses. Yeah. No matter what type of game, every appearance and every bonus but one was lower for the women. Yeah. I'm not so sure about the equal work part of this equation. You know, I'm not sure about that, and yeah, I'm not sure that makes sense in this context. This, if true, would presumably require the women's NBA to be paid as much as the men's NBA, which seems like a strange proposition for a commercial enterprise. Yeah. The women's and men's collective bargaining agreements have some differences. Yes. Most notably, the women's agreements divides the players into two groups, contracted and non-contracted. That's right. They do. Because in the men's team, they're all essentially non-contracted. They have an agreement that says how the men will be paid, but they don't actually contract with any of the men. They contract with the team, but not the men. So in the case of the men's team, the Federation, if they were so inclined, doesn't have to look for any games, doesn't have to try to find any games. The Federation can do F all if it wants. And the men would be paid nothing. Because that was the nature of their agreement, right? It's like, yeah, they're all essentially non-contracted individually. So at any given time, the Federation for the men's team can pick any player they want because they're all required to play because that's part of the deal, right? You're required to play for us, but we're not required to not required to find you a place to play. So if we want you, you have to play. If we don't want you, go away. So that's part of the deal. So all the men are essentially non-contracted. They get F all if the team, if they don't play, which is within the Soccer Federation's rights, because that's how the contract is structured. For playing in games, contracted players receive an annual salary, which is kind of important, while non-contracted powers receive an appearance fee per game, like the men's team. Yeah, and also, this is just a little fun point, which I think says something about the women's team. Not all the players of the women's team were contracted. Right? Now, I presume, but I wouldn't know for sure, but I presume that the Soccer Federation would have been willing to strike a deal of some kind for all the players to be contracted. Now, it might have been different in substance because they have to give out guaranteed more money. But, but the women's team, when they were negotiating for the contracted, they didn't negotiate for all the women. So, something about the sisterhood and being bonded, I'm not 100% sold on that one. Under the men's agreement, all men per game receive a per game appearance fee and performance bonus. True enough. Even accounting for these differences, the value of the women's agreement is much lower than the value of the men's agreement. The risk profile is also different. The women expert demonstrated that fact by calculating how much more the women would have been paid had they been compensated the men's agreement. And also the men would have been paid more if they had been paid under the women's agreement. So it appears that both the men and women are bad negotiators, it turns out. Because the women would have been paid more under the men's agreement, but as it turns out, the men would have been paid more under the women's agreement. So apparently both negotiators negotiated poorly. They would have been better off just handing each other their deals and signing those. So, yeah. Which also, and I've said this before because it's such a dick move, but it's allowable by law. When you're talking about an equal protection issue, which this ultimately is, because we're talking about equal pay, right? So we're talking about equal pay for equal work. Men and women have to be treated the same. So that's an equal protection issue, right? So when you're talking about equal protection, if you find a violation, you can do one of two things as a court. You can either level up or level down, right? So either you have to take everyone who's not getting as much and bring them up so they're getting as much, or you can take the people who are getting more and bring them down to the people who are not getting as much, right? Leveling up, bring everyone up to the same level. Leveling down, bring everyone down to the same level, because then it's equal either way. So that's part of equal protection. So what I've sort of said half jokingly is if I were a judge on the Court of Appeals, I'd be sorely tempted to say, you know what, you're right. There is a disparity between the men's and women's pay. Now, because I can level up and level down, I can do one of two things to remedy this problem. I could give the women's team the men's deal, but I could also give the men's team the women's deal. So you're right, women, the men get paid more. I hope you're happy. Such a dick move. Such a dick move. So tempted. Even accounting for the differences, the value of the women's agreement is much lower than the value of the men's agreement. They demonstrated that fact by calculating. Yeah, these 4 class representatives would have earned on average an additional $2.5 million each. If all the women in the classes had been paid under the men's agreement, they would have earned an additional $64 million. Well, let's talk about how much more the men would have been paid under the women's agreement, The women asked the Federation to pay the same as men, but the Federation refused. During collective bargaining for the women's team, the Federation offered women the same pay structure as the men. That is, they offered to eliminate contracted players and play all of them per appearance fees and per bonuses, but the Federation refused to offer the women the same dollar amounts as men for the appearance fees and bonuses. The Federation admitted that. The Federation agreed it's undisputed fact the bonuses in the proposal were lower than those found in the men's agreement, which seems to slightly contradict what the women had said publicly, but okay. Sunai Giuliatti stated in an affidavit that he would never have authorized offering or accepting equal bonuses for men because they're not bringing in equal revenue. If you want to talk about pay for performance, we can measure performance in a couple different ways. There's obviously the performance on the field, but how about the performance in bringing in fans? How about the performance in bringing them in at a higher ticket price? How about the performance in getting your merchandise adequately sold, and so forth and so on. Maybe the performance isn't just strictly on the field. Many of the Federation sponsors, including Coca-Cola, Volkswagen, Anheuser-Busch, Visa, and Deloitte, have spoken out against the Federation's unacceptable treatment. Well, I definitely care about those corporations' opinion for some reason. One sponsor took out a full-page advertisement in the New York Times urging the Federation to end gender inequality once and for all players. It's this kind of thing that makes me want to say, you're right, the men get the women's deal, let's give the men more money. Because then they'd be equal. It's just so tempting. So tempting. Members of Congress has also recognized the Federation's discrimination. For example, in 2016, the Senate unanimously passed a resolution recognizing the Federation consistently paid the members of the United States women's team less than similarly situated players of the men's team. How similarly situated are they, though? And urging the Federation to immediately end the pay gap. The men's team also called out the Federation's pay discrimination. The men's team issued a public statement which criticized the Federation for discriminating against the women and their wages. It noted that for more than 20 years, the Federation has resisted any concept of equal pay or basic economic fairness. I'm not so sure about the basic economic fairness. If we're talking about economic fairness, we have to look into everything that forms the economic factors, right? For the women's team, it therefore detailed how much the women's collective bargaining agreement are worse financially than the men's agreement. According to the men, the women should have received at least triple in player compensation compared to the men because of the women's immense success. To the men, its solution is simple. Pay the women significantly more. It's not money coming out of their pocket, so, what do they care? But, the Soccer Federation has an opinion, and also they're entitled to have their contracts. So, even if the Federation had admitted it doesn't pay women equally, they admitted it doesn't pay women equally. In 2017, the Federation's vice president and future president confirmed that female players had not been treated equally. He was campaigning for president at the time. Part of his platform was a promise of equal pay. He said the Federation clearly needed to work towards equal pay for national teams, and ensuring equal pay was the right thing to do. But once elected, he reneged on that promise, commenting only seeking more opportunities for the women's team. Further, during collective bargaining for the 2017 agreement, the women's team asked to be paid the same appearance fees and bonuses. The Federation expressly refused. The reason provided by counsel was the market realities are such that women do not deserve equal pay. Well, that's a bad way of phrasing it, but it's the right idea. It's like the market realities, you're two different teams. You're run by the same umbrella branch, but you're different teams. I'm just going to take a guess. And I'm going to assume you can do this. You could just do this in basketball or football, like the NFL or the NBA, right? The NBA is composed of many teams. The NFL is composed of many teams. The market realities for all these teams are not equal. Some teams get more money. Some teams are more popular. Some teams can charge higher prices. Some teams' merchandise is more popular. Some teams have better broadcasting deals. Amazingly enough, it's not discrimination on the basis of sex in the case of the men's team for the NFL or the NBA. The discrimination, such as it is based on the market. And so this is not exactly eloquently phrased, but saying the market realities is like, yeah, we literally can't give you the same money because the market doesn't support it. It is uneconomically viable. Where are we supposed to get this money? It's just not there to be found. So, this is also like a fallacy of the whole thing, right? This is a fallacy of the whole thing. If it were true that the women's team had to have the same contract as the men wouldn't have the contract they do. It'd be impossible. If the women's team and male teams had to have the exact same contract, they would not get the men's contract as it now exists. There's just no way. There's not enough money in the system. the men would be getting paid lower, and the women would be getting paid an equal amount. And also, it's not inherently obvious off the top of my head that the women would be paid more in that hypothetical universe. It's possible, but it's not inherently obvious. So they might both be worse off being paid equally, because the market just doesn't allow for that at the current pay rates. The market is undefeated. That's not what the market is. You know better than that. The market is undefeated. That's not what the market is. You know better than that. The market is the people who are watching the games. The market is the people who are attending the games. The market is the people buying the merchandise. The market is the people watching it on TV. That's the market. At that point, the Federation was earning record revenues from the women, as is projecting they would earn more from the women games than the men games within the next year. And yeah. The Federation has relied on sexist stereotypes to amplify to justify discrimination. In his deposition as one of the Federation corporate representatives, the former president asserted that based on genetics, biology, and so on, the absolute quality of the women's team was lower than the men's team. That is a biological reality. That isn't, I'm sorry and all, that's not sexism. It's just reality. Men and women are, in fact, not biologically equal. I know. I'm sorry to break this to you, but men and women differ. Now, that doesn't mean that you can't find a woman who's stronger than a man. It doesn't mean that you can't find a woman who's stronger than a lot of men. It does mean that the strongest women and the strongest men will never be equal. The men always will perform better. It's a biological reality. So again, maybe the phraseology is a little bit inelegant, but to say that due to genetics, due to biology, the women's team can't perform at the same level of the men, that's just a biological reality. Do we believe in science or don't we? Or is it one of those things that we believe in it when it's convenient? You know, this isn't to say that women are inferior. They're not. They're not inferior. And first of all, women have advantages that men don't have in other domains. So it's not like women are inherently worse at everything. Women are superior at other things to men. There's balances in the equation. So, you know, but when on straight physicality, you know, not as much. So, you know. In summary judgment briefing, the Federation relied on sexist stereotypes, asserting it can pay the women less than men because it's indisputable science. The women's teams are less skilled than the men. But yeah. Because the men face tougher competition. Yeah. And because the men carry greater responsibility than the women. I don't know what that means, but maybe. After significant blowback from sponsors, the then president resigned. The Federation hired new lawyers who disavowed those arguments. Ineloquently phrased, but, you know, biological reality is a thing. It doesn't mean that women should be treated worse. It doesn't mean that women are not equal. It doesn't mean that in equal situations, as in like most workplaces, they should be treated as equal. But this is not your average typical workplace. This is a bit different. This is one that requires on pure physicality. You know, if you were a business that for some reason that passes all understanding required your employees to regularly lift large amounts of weight, that would be a factor. It's one of the reasons, for example, they'll ask you, like, are you capable of carrying 40 pounds? So that you will, you know, so if you say yes, then great, carry these 40 pounds. But I'm a woman, but we're treating you equally, right? $10 from Provolone Loaf. Appreciate all the hard work you're doing on this channel. Keep the fun going so we can learn from the misfortune of others. Yes, I do try to make it as fun as the situations allow for, because I find law fun. And I find the analysis fun. And it's like, yeah, I don't think it can really be thought of as sexist. How can it possibly be sexist to say, here is a reality. Men have more upper body strength. Men are typically better at straight physical endurance. That isn't to say that there aren't women who can kick the ass out of men. But, when you're going to the end of the distribution, which is typically where you're looking to hire, right? The NFL/NBA is not looking to hire the average man. They're looking to go to the extreme end of the bell graph, right? They're going to the extreme end of the bell graph, get the best they can. So, at that edge of the bell graph, if I'm reasonably confident that if there was a woman who could compete on a professional level with a man in the NBA, I'm reasonably confident the NBA will be happy to hire them. Yeah. The Federation hired new lawyers who valid those arguments and expressly stipulated the women's players are equally skilled as men. Including key areas of soccer such as athleticism, tactical IQ, which maybe they are. That's possible. I mean, the women might be smarter. That might be fair. Tactical proficiency, that could be true. And mental fortitude, which could also be true. Not so sure about the athleticism. But it might be true that even the women might be better on tactical IQ. The women might be better in tactical proficiency. They might be better in mental toughness. It's possible. Or they could all be equal on those things. But, I'm somehow doubtful. In March 2016, the 4 class representatives filed charges of discrimination with the EEOC. They investigated and issued a player right to sue letter, which is a perfectly valid thing for the EEOC to do. In this situation, they should have issued that letter. They only have to have a plausible case. So the EEOC did the right thing here. In March 2019, all 28 members of the women's team filed this lawsuit. They alleged the Federation violated the Equal Pay Act and Civil Rights Act by paying them less than men because of their sex. Is it because of sex? Is it really because they are women as such, or maybe because the revenue and economics are not the same? As is pointed out in the chat, the women's team lost to a group of teenage boys. It was, what was it that, when it was Serena Williams and Vanessa Williams who said, we can take on any man, and then lost to someone who is 230th ranked among the men. It's we're as good as any man. And the women only got 1 point in 3 matches. Otherwise, the man completely left them with no points. So in 3 matches, they got 1 point, and otherwise the man smoked them. And he's 225th best man in the world, taking on the number 1 ranked women. It wasn't close. Yeah. And then the women's team were schooled by a bunch of, amateur high school or college boys. I can't remember exactly, but yeah. There might be a difference in genetics here. It might not be discrimination. Maybe reality is discriminatory, but, what do you want from me? The parties have settled the working condition claim and they're not issued that appeal. Okay, so whoever said it earlier in chat is correct. They have since settled the working conditions claim. So the airplane, hotels, logistics side of this equation has been resolved. The district court granted summary judgment to the Federation's equal pay. The district court acknowledged the Equal Pay Act requires that men be paid an equal rate of pay, and women cannot be required to work more than a man to achieve the same pay. But the court nonetheless used what it called a total compensation approach, where it divided the total amount of each team earned by the number of games played. The court calculated during the class period the women's team was paid an average of $220,000 per game, and the men's team was paid an average of $212,000 per game. Because those numbers were approximately the same, the court determined the men and women received an equal rate of pay. This does not account for performance. Specifically, the women had to be the best in the world to make the same amount as much less successful men. Also, you're not accounting for the guaranteed pay thing. The district court did not independently analyze the women's Title VII pay discrimination claim, which is probably fair because it would come out the same. Instead, it concluded because it had no tribal issue under the equal pay, the Title VII claim fell as well. The equal pay claim is probably more specific. The Title VII just prohibits a generic discrimination on the basis of sex. So yeah, that seems fine. The district court then downplayed or dismissed the women's evidence of unequal pay. First, it refused to consider the difference in pay in the terms collective bargaining agreements. It took the view the agreements could not be compared because some women may receive salary and other benefits the men's salary do not receive. Right. That's important. Yeah, they can't be compared because the women's team has different guaranteed things in it. That says, yeah. Next, the court dismissed the women's expert evidence about the comparative value. The women's expert valued all the compensation and benefits in the team agreement and found the women would have been paid $64 million if they had been compensated under the men's agreement. And the men would have been paid more if they had been paid under the women's agreement. The Federation provided its own expert to analyze the comparative value. Rather than recognizing the dual experts based on facts, the court simply disregarded it because it's immaterial, right, in the court's analysis, right? It doesn't matter to the court if they would have been paid $64 million or some other number. So there's a dueling experts, but in the court's opinion, it doesn't matter, right? The court in summary judgment only has to consider legally operative facts. Summary judgment is inappropriate if there are facts that are legally operative. So the court can disregard any facts that are not legally operative. And the court's basic analysis is, look, they bargained for different things. They made different choices. And, so the fact that the women would have been paid $64 million or literally any other number is kind of near here nor there. I don't have to resolve the factual dispute. I just don't care either way. Which, that seems like a reasonable approach to my mind. The district court also took the view that women could not argue their pay was unequal because the union had agreed to it in collective bargaining, particularly where they rejected apparently the same equal pay, as was said by one of the women. The court stated that women's and men's team bargained for different agreements which reflected different preferences. Yeah. The women's team expressly rejected terms they now seek to retroactively impose on themselves. Yeah, the women's team would have, assuming the women's team were not offered an equal pay, they would have had a much better argument if they had accepted the exact same structure, right? Because they'd be like, yeah, our contracts are equal. It's the exact same structure and we got paid differently. But the women didn't do that because they wanted different things. And so here's the operative question, I suppose. Are women not allowed to want different things? Are the women not allowed to have preferences? Are they not allowed to have different wants and desires? Are they eternally bound and necessarily bound to male preferences and male desires and not allowed to have preferences of their own? That seems a bit of a backwards conclusion to my mind. Under your theory of the case, women aren't allowed preferences. They aren't allowed choices. They must go along with whatever the men want and the men's choices. Yeah, I don't know about that one. Finally, the district court dismissed statements from the Federation representative admitting the Federation not paid women equally. Those statements include the former president's recognition that our female players have not been treated equally. Federation counsel stating that women do not deserve equal pay, which, yeah. The court credentialed the president's after-the-fact explanation that equal pay was only about how the women should have more opportunity. And the court dismissed the statement on counsel that the ground he disputed making the statement. Yeah. I think it's, if I had to project the most probable result, I think the most probable result is the Court of Appeals returning it for some sort of technical reason, like these little minor quibbles that don't really matter, and saying like, okay, they don't really matter, but we're going to pretend like they matter so that they have to go to trial and then present it to a jury, right? So if I were my druthers, and I could be wrong, maybe we'll get lucky. But I think, unfortunately, the most likely conclusion is the Court of Appeals to point to some of these more minor issues and say, aha, that's a factual dispute and actually does matter. And the district court can't do that. So it has to send it back to trial for resolution of that fact. And incidentally, while resolving that fact, although we're not going to say the quiet part out loud, they can also be presented with all the other things so a jury can sort it out. Yeah. But on the plus side, On the plus side, if the Ninth Circuit reaches that conclusion, I feel like there is a non-zero probability the U.S. Supreme Court might take certiorari. So just to state the basics, the certiorari approval rate by the U.S. Supreme Court is 0.8%. They take less than 1 out of 100 cases. So, if you're a betting man, you also have to predict against. But then you're like, okay, can I, as an attorney, recognize cases that have better than average probabilities? I'd like to think so. And I like to think this is one of those cases that has better than average chances. So I can't, of course, guarantee the Supreme Court will take the case, because what do I know? But if you ask me, does this have better than normal chances of being taken by the Supreme Court if the women win? I'd have to say yes. So maybe we'll wind up at the U.S. Supreme Court, which will be hilarious. The women's players are some of the most successful athletes in the world, but their employer, the Federation, consistently has refused to pay them the same as players on the women's team. No matter what the women's team beat or the tournament they win or what accolades they receive, the Federation treats them worse than men. That unequal compensation is clear from the face of the collective bargaining agreement. It was documented by the women's expert economist, and Federation representatives directly acknowledged it. Based on all the evidence, a reasonable jury could find the Federation had violated the Equal Pay Act. I think there's just enough here for the Court of Appeals to sink their teeth on without me unfortunately calling it ridiculous. So as much as I might eventually disagree with the Ninth Circuit Court of Appeals, I feel like there's enough here that I'm going to unfortunately have to reach the conclusion that the Court of Appeals reversing the district court is actually a reasonable judgment. You know how much I don't want to reach that conclusion, but I try to be intellectually honest as much as I can. And I feel like there's enough here that if the Court of Appeals wants to reverse, there's enough here for them to hang their hat on. And then I'm going to very sadly have to say, yeah, this decision from the Court of Appeals is actually reasonable, as I grit my teeth and give the legal analysis. So I'm looking forward to that in the future. That's just great. I tell you guys frequently, I can't always tell you what you want to hear. I can't even tell myself what I want to hear all the times. So, yeah. The district court used the wrong legal standard under the Equal Pay Act. The act requires an employer to pay women and men doing equal work for an equal rate of pay. Equal rate means equal pay for equal work. Thus, an employer must pay a woman the same amount it pays for a man for each measure of work. Here, the workers is measured by both number of games and results. The Federation pays players not just to play, but to win. The district court did not account for performance in the Equal Pay Act, even though incidentally, one of your people who was suing again said quite publicly that they shouldn't be paid on performance. They should just be paid for playing games. So again, we're changing our mind. Yeah, we're in the Ninth Circuit. Yeah, this is California, so this is Ninth Circuit all day long. So yeah. Here, the players' work is measured by both numbers of games and the results they achieve. The Federation pays the players not just to play, but to win. Yeah, it's kind of true. My mic is clipping when I get excited. Yeah, it's hard to balance the mic properly so it doesn't clip, and it's also loud because people keep saying to take it. So I'll just move the mic further away and see if that helps with the clipping. Let's see if there's any questions for the bot. There are no questions for the bot. If you want to ask a question, begin your chat with the word question. There you go. So that I will see your question, because I want to make sure I'm getting your questions, and you might not have known that from the bot, so that's fine. I will inform you about that. This is a bot to monitor for that, so I can see questions as opposed to chat that's not intended for me. Okay, let's press on. The Equal Pay Act forbids a woman making a woman work more or perform better to achieve the same pay as a man doing the job. Question, am I getting your question? Well, let's see if the bot picks it up. Otherwise, this is going to be a really sad day. Michael, did Matt, did the bot break? Nat, I think the bot broke. It's not, the question isn't being captured. Matt, fix the bot, Matt. Matt is a great editor. I just give him a hard time sometimes because it's part of the shtick of this channel where I give Matt a hard time, but he's a really good guy. So we always appreciate the stuff that you do, Matt. It's always helpful. Maybe Discord's just being really, really slow. The district court also erred in treating the equal pay analysis as dispositive under Title VII. See, that would be another basis for the Court of Appeals to reverse, which I don't think they should in this pattern, but, what do I know? Title VII prohibits sex discrimination in employment, covers a broad range of discrimination in employment than the Equal Pay Act. That's true enough. But in this particular situation, your discrimination is based on pay, so they kind of overlapped in this pattern. Well, I got a question from Marissa. So Matt is now apparently going to add to the bot manually. This should be fun. You're a trooper, Matt. Even if the district court were right about the Equal Pay Act, the jury could find violation of Title VII based on the woman's consistently lower fees and bonuses combined with the statement of discriminatory intent. But in this case, the discrimination is over pay, so I think they might overlap legally. Not necessarily the Ninth Circuit will agree with me, but In addition to those legal errors, the district court incorrectly dismissed the player's evidence of unequal pay on summary judgment. First, the court should have considered the obvious disparities in the terms of the women's and men's collective bargaining agreements. The court believed the agreements could not be compared because some women earn fixed salaries and benefits. But those aspects of the agreement can be valued. Yeah, and they are also valued from the sense not only economically, but also to their risk factor. Is Matt getting equal pay? He's getting as much as any of the other editors are. But those aspects of the agreement can be valued. The court also believed that women chose lower bonuses in exchange for guaranteed salaries. Yeah, but salaries were not guaranteed. A player could be cut from the team at any time. They had guaranteed slots. And even with the salaries, the overall value of the women's agreement was much lesser than the men's. Significantly, the Federation never offered the same deal as the men. This confirms the agreement were nowhere near in value. Second, the district court erred in dismissing the testimony of the women's expert economist. The expert calculated the women's rate of pay was much less than men's, taking all into account the differences in account. She showed the women would have earned much more if they had been paid under the men's agreement. The court refused to consider this evidence because the agreements were a product of collective bargaining. But it's well established a union and employer cannot bargain away employees' rights to equal pay under the Equal Pay Act and Title VII. So we want to throw Megan under the bus? You understand that means that you were throwing Megan Rapinoe under the bus on this one there too, but okay. The court also suggests that women rejected the men's deal, but that's mistaken. The Federation offered the same pay structure, but never the same amounts. Which, given the different, again, because that wouldn't be discrimination on the basis of sex, at least to me, right? They would be getting paid different numbers, but it's not discrimination on the basis of sex. Why would the men and women be treated differently? If they had literally the same structure, the men's and women's team would have been paid differently. Why? Because under the exact same structure, the men's revenue and the women's revenue is not the same. Right? So it wouldn't be discrimination on the basis of sex in that case. It would be discrimination on the basis of the economic reality. I'm not treating you worse than the men. In fact, I'm giving you exactly the same deal as the men. The reason the pay won't be equal has nothing to do with that. It has everything to do with the economic realities and the pull of the men versus the pull of the women. Right? So even if so that wouldn't be discrimination on the basis of sex, at least in this jurist's opinion. Is the bot working? Hey, it looks like the bot might be working now. Hooray. So let me answer some questions and we'll hope the bot is working. Question, do you know how much the U.S. women's team are making compared to other women's teams in the world? No idea. Sounds like they're getting a ton of money for work. Couldn't speak to that. Question, how can they even argue disparity with a contract they negotiated and voted on by members? I don't know. Good question. A contract that's completely separate from men's, and isn't there quibble really with FIFA? Might be. Do they calculate the cost of benefits of the women's team in regards to their overall compensation? It looks that way. But yeah, if they had been offered, they would never be offered the same money because the economic realities are different. So it wouldn't be discrimination on the basis of sex. This argument is dumb. Test, fixed it. Google decided to stop the virtual machine. Okay, great. So now the bot is working. So now if you want my attention, you can begin a thing with question and the bot will see it. Hopefully, maybe we'll see. Finally, the district court should not have discounted the women's team's players' direct evidence of discrimination. This is a rare case where employers admit it's paying women unequally, and the reason is their sex. Not exactly. Former Federation president acknowledged the female players had not been treated equally, and the Federation clearly needed to work for equal pay for the national teams. Former president attempted to justify the unequal pay, saying the absolute quality of the team was lower than men's because of genetics, biology, and so on. That is a reality in this situation. It's not for nothing that all the waitresses at Hooters are female. The Federation Council stated during collective bargaining that market realities are such that women do not deserve equal pay. Right. I would have said such that women cannot get equal pay because there is simply not enough revenue that would allow for that. So deserve is the wrong word choice here, but right idea. The district court was supposed to view all evidence in the light most favorable to the players. That's absolutely true. That's absolutely true. In a summary judgment, yeah, any disputed evidence, yeah, you should view in the flavor of light before you reach a summary judgment. Yes. The court should allow a jury to resolve the evidence in considering factual disputes. The court's idea is that there are no factual disputes that matter. Question, for real, isn't this a form of tortious interference where they're now arguing and suing over a contract they agreed on? They can't tortiously interfere with themselves. So, no. Yeah, they can't tortiously interfere with themselves. It's a contract between them and soccer. So them suing is not tortious interference because they can't tortiously interfere with themselves. They can break the contract or interfere with the contract, but it would be a breach of contract, not tortious interference. Our writer says, if I'm a female rock star with number 1 but a lousy contract, do I have to be paid the same as a male rock star as a better contract but has only number 10? Right. Amazingly, men and women are paid different in music, not necessarily based on sex, but based on, the ability of them to drag in audiences. Yeah. The bot does seem a bit slow because I'm waiting for the bot to pick up with our writer's next question. Oh, no, the bot got it. Yeah, it's butts in seats and men draw more butts. It's not just butts in seats. It's also butts in chairs at bars watching the game on TV, but yeah. Okay, standard of review is de novo with deference. Yeah, that's correct because we're coming ultimately to a legal conclusion. So yes, de novo review is the correct review. The women's team brought claim under Equal Pay and Title VII. Both statutes prohibit sex-based discrimination. The Equal Pay Act requires employers subject to its term to provide an equal pay rate of pay. It provides that no employer shall discriminate between employees on the basis of sex by paying wages to employees at a rate less than the rate at which he pays wages to employees of the opposite sex for equal work on jobs, the performance of which are required equal skill, effort, and responsibility and are performed under similar working conditions. Not so sure about that. The statute's four affirmative defenses permitting unequal pay is due to a seniority system, a merit system, a system which measure earnings by quality or quantity of production, which this seems like that situation to me, measures earnings by quantity or quality of production, how much bucks are coming in, or differential based on any other factor other than sex. Yeah, it's only sex-based discrimination if we're discrimination on the basis of sex. if we have a other reason that's not a pretext, right? So it can't be a pretextual reason, right? So here's how it works. The first side says discrimination on the basis of sex. The second side says we have this valid reason. Then there's rebuttal that's not a real reason. That's just a pretext, right? But the real reason seems to be a real reason. The real reason is economics. It's not a pretext. It's reality. The teams are bringing in different revenue. We're paying the women and men differently because of the different revenue they bring in. We offer them the same structure and they would have gotten paid less because the different revenue. There, for better or worse, the Title VII and the Equal Pay Act prohibit the employer from discriminating, but it says nothing about the general public. The general public is in fact allowed to discriminate on the basis of sex or any other basis that pleases their fancy. So maybe the men's games and women's games should be as popular and they should be equally attended and blah, blah, blah. But, the general public is allowed to discriminate. And if they do, they are allowed to say, okay, well, we're taking note of that discrimination and forming it based on that, which isn't us discriminating, it's the public. So, yeah. If the Olympics did less to promote the women's team, could they have an argument there? The USA Olympics, I don't know about the pay structure or something for the Olympics. So I don't know how that works. So I'm not going to opine on to the Olympics because I don't know enough about how they're paid or have promoted to really offer an opinion. But if there's maybe is the best possible answer, right? But I don't know enough to offer an opinion beyond that. Under equal pay, the plaintiff must establish a prima facie case of unequal pay, which you're there. Then the burden shifts to the employer to give an affirmative defense. To establish the case, they must prove it to a employee who is employed at the same establishment as plaintiff, which isn't clear it's true, performs a job that requires equal skill, effort, and responsibility as plaintiff, which isn't clear it's true, performs a job under similar working conditions as plaintiff, which isn't clear it's true, and nevertheless receives a greater rate of pay than the plaintiff's, which sure. But no evidence of discriminatory intent is required. That's true. You don't have to prove they intended to discriminate. That's true. But we'll take all that as a given fine. Title VII prohibits sex-based discrimination in employment. It says it shall be unlawful to employment for an employer to discriminate against any individual with respect to his compensation terms, conditions, privileges of employment because of sex. Yeah. To show sex-based discrimination, plaintiff need only to show that sex was a motivating factor, even though other factors also motivated the practice. That is true. That is true. Because if sex is a motivating factor, then you were discriminating on the basis of sex now, weren't you? You might have been discriminating on a whole bunch of other reasons, but if sex was a motivating factor, then yeah, you're there. Yeah. A plaintiff can show Title VII using direct evidence or indirect evidence. Title VII uses a burden-shifting framework. There's enough here for the Court of Appeals to latch onto if they want. There's no burden shifting when the plaintiff provides direct evidence of discrimination. Because direct evidence is so probative, Title VII need offer very little direct evidence to raise a genuine issue of fact. As a general matter, any violation of the Equal Pay Act is also a violation of Title VII. True that. But in actual practice, it is not a violation of the EPA, may nevertheless be a violation of Title VII. I'm not sure that's true specifically in the context of pay. Title VII is broader than equal pay. It requires only proof of treated worse because of sex, not they're doing equal work at the same establishment. Yeah. In this case, the district court addressed only one question, whether the women's team and men's team received equal rate of pay. Because the court concluded players on both teams received an equal rate of pay, it did not independently analyze the Title VII issue. The court did not address other elements of equal pay or any affirmative defenses. As explained below, the district court used the wrong legal standards and incorrectly dismissed the women's evidence. There's enough here for the Court of Appeals to reverse and say that the district court applied the wrong law. And chide them while they're doing it too, depending on their mood. No, text message. Hold on one second. Okay. Let's carry on. For my money, and maybe I'm committing a legal error. It's possible. I'm not God. I just give you a legal opinion. And maybe I'm committing a legal error by agreeing with the district court. It's possible. It's possible. There's enough here for the Court of Appeals to hang their hat on. So maybe me and the district court are wrong. But I thought the district court's analysis made sense to my mind. This is not a situation where you can compare apples to apples. The realities are just not the same. And so the Court of Appeals may very well whack them around and say, yeah, you needed to consider this differently. You shouldn't have dismissed this. Title 7 shouldn't have been subsumed. You should have let this go to a jury. And then they get to bring everything in and cry a sob story and blah, blah, blah. And it would be very possible, incidentally, it'd be very possible the Supreme Court might not grant cert now because they'd be thinking to themselves, well, once the judgment is in and that's appealed, we'll take the cert then. But it's not clear that the Soccer Federation would appeal if they lose. So, even though, well, maybe it is clear because it does mean giving them, $46 million? And I mean, that's not chump change. They may simply not have the money. They may not have the money to pay them. So if that's the factor, then yeah, they would keep going because they literally can't. Or maybe they reach a settlement like, we'll pay you over time or some nonsense, but whatever. Again, I try to give you the best legal analysis I can and also try to highlight opportunities where I think my legal analysis might be wrong. This is how intellectually honest I try to be on this channel, and also why I get a little bit irritated at times when the chat is saying things like, you're not being intellectually honest, or in response to that first video I did on the Utah corruption thing, comments saying like, you're a fundamentally bad person, you're evil, you're a statist, you're this, you're that. Or in the response to the Katie without a crystal ball thing, people saying, oh, you're biased, you're a shill for Katie, you're a boy toy, and all the rest of it when I did that first video. This is one of the reasons I get so irritated, because I take my integrity fairly seriously. And when I'm analyzing a case like this, and I'm like, there's enough here for the Court of Appeals to sink their teeth on if they want. That's certainly not what I want to be true. I kind of agree with the district court, but, I just try to tell you how it is, for better or worse. This is my legal opinion. And also, my legal opinion might be wrong because there's enough here for the Court of Appeals to sink their teeth into. So, I hope that's worth something to you. I hope that's worth your subscription, to put it quite frankly. I hope it's, again, I'm not God. It doesn't mean I get everything right, but I try. I try really hard. The district court reasoning suffers from a fatal flaw. It does not account for the effect of performance bonuses on player compensation. And I also say that knowing full well, saying full well that to the extent that people were following me over from Nate's channel, I may have already lost them at this point in the video because they just want to hear nothing but rah, 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 and this is all garbage. And then when I do the deeper dive legal analysis, and I'm doing the actual analysis and going into it, I'm like, there's some good points. And there's some people like, I don't want to hear from that. Unsubscribe. I just want to hear about how the women are evil. So I'm throwing away subscriptions by doing this. This is just great for me. Let me tell you that. Pressing on. Enough whining about my life. Let's press on to the case. The equal pay mandate is simple. The act requires employers to pay their male and female employees who do equal work an equal rate of pay. Women and men reserve an equal rate of pay when they receive the same amount of compensation for the same measure of work. If compensation has multiple components, each reflecting different measure of work, the rate for each component must be equal. The rate. What does it mean for the rate to be equal? I mean, can't the rate be based on total economic realities? Take, for example, a shoe store that pays its salespeople an hourly wage and commission. The Equal Pay Act requires the store to offer its men and female stale employees the same hourly wage and same commission. I don't think performance at the shoe store can really be compared to performance in professional athletics. I don't think a shoe store requires a great deal of skill. I think being the women's soccer team requires a great deal of skill. I don't think they can be compared. You're saying that women's soccer is like a shoe store. Yeah. The employee cannot offer female employees a lower wage or lower commission, expect them to work more hours, sell more shoes, or do both to earn the same total. Yeah, I'm not sure that's really a comparable. The plain text of the Equal Pay Act reflects that understanding. It prohibits an employer from discriminating on the basis of sex by paying employees at a rate less than the rate at which the employer pays other opposite sex. By using the word rate, Congress required equal pay for each measure of work. The word rate reflects not the total amount, but an amount per unit, whether the unit is time, item sold, or gain won. If Congress intended to require only that female and male employees receive the same amount of pay overall, regardless of quantity, it would have said so. Well, that much is fair. For example, Congress could have referenced total compensation as it did elsewhere. That's totally fair. That's a totally reasonable argument, right? Congress didn't use these words. It was referring to something else. It was referring to something else. I don't know if it had this situation in mind when it was considering the Equal Pay Act or Title VII. And I'm not sure necessarily what the best conclusion is here. But yeah, I think the situation, because it's discrimination based on other than sex, because of economic realities. So yeah, I think that's the right conclusion. Get a little background music here. I don't know if you can hear that or not, but I can. The EEOC has issued regulations and guides to confirm this point. The EEOC regulations define rate as the standard or measure by which employee rates are determined, which might very well be economics, right? If you're in a shoe store, the economics are what does the shoe store bring in, because it's a shoe store. If you're a chain of shoe stores, it's the chain of shoe stores. For the men and women's team, I'm not sure you're equal and comparable. Is the mic picking up that? Let's see. The understanding is consistent with the Equal Pay Act's performance and common sense. The act was designed to correct a serious and endemic problem of employee discrimination in private industry. Pay discrimination based solely on the outmoded belief that man, because of his role, should be paid more, even though his duties are the same. That's perfectly fine. Preach that. If you are working in an industry which the men and women's work is equal, which is like basically all of them. So if you're working in a bar, if you're working in a shoe stop, if you're working kind of anywhere and your duties are the same, then yeah, pay them the same. I'm not sure this situation is encompassed by that, though. In light of that purpose, Congress could not have intended the absurd result an employer could pay women $10 per hour and men $20 per hour. That's true. For a common employer in a common factory or a common bar or a common shoe store, right? Many courts have recognized that an employer violates equal pay when female and male employees receive different performance bonus rates, even if their total compensation is the same. Fair enough. Provolone apologize. Let's try that again. Provolone Loaf gives me $10 and says, your intellectual honesty is why I prefer your analysis over people like Rakita, who introduced me here, though I still watch your streams. Your objectivity is what I want in a judge law tutor. I try, man. I try. Doesn't mean I always get it right. Especially like in that first stream I did on the attorney selling out / conspiring against their clients, where I got totally lost in the whether the judge made a mistake issues and kind of neglected did the attorneys make a mistake issues. So, I kind of got lost in one end of the analysis and forgot the other end of the analysis. And then I had to revise. I'm like, oh yeah, there's an issue here. So, yeah. So I make mistakes. I'm human. It happens. And then when I make mistakes, I try to acknowledge them, right? The Fourth Circuit made the same point in EEOC. There, the employer guaranteed a minimum salary to each sales manager plus commission for each house that he or she sold, with lower commission rates for women than men. The district court compared gross earnings of female and male sales managers, but Court of Appeals rejected that approach. Citing EEOC defining rate, the Court of Appeals concluded that female sales managers now have a prima facie case because women receive lower commissions than men. Yeah, again, they're selling houses in the same office. There's nothing inherently that would suggest to you, like if you're asking in the abstract, would a man and woman do this job differently? Nothing obvious or better. There's nothing obvious. So sure, pay them the same. Makes sense to me. Not sure that reads here. I mean, if you take that argument literally, or if you take the women's argument literally, it would suggest that like the NFL and NBA should have to hire equal numbers of women and men, which it's probably not the right legal result, right? As another example, female police communication officers allege they pay less than male fire commission officers. I don't know if there's enough difference there between police and fire to justify that. I mean, one would think that comparable between female police and female fire and male fire. Maybe there's not enough female firemen or something to make a comparison. I don't know. The employer argued pay was equal because women had been put in so much overtime that some of them received total remuneration. That's the wrong argument. The court rejected it, saying it speaks of rate, not remuneration. The law is clear. Under the Equal Pay Act, the employer must provide its male and female employees with the same rate of pay. Which, if that's true, then they would never have made that deal with the men. They wouldn't be able to. They wouldn't be able to sustain it. So I think that the answer is, if you come to the conclusion they have to be paid the same, I don't think that means that it's paid under, because the error here was in the contract, right? The error here was in the contract. And so now we would say, well, what would have happened if they had to make the contracts the same? They would never made the deals they made. It's impossible financially. So yeah. And it's not necessarily clear that the women would get paid more, depending on how that all evens out. So I don't know how it evens out, but yeah. What are we going to do? We're going to take money away from the men. What's that called? There's a term for that. Damn it. Why can't I think of it? There's a term for that when you take money back away from somebody. There's a legal term for it. It'll probably cross my mind later. The law is clear. Under the equal... Okay, we covered that. The district court used the wrong legal standard in assessing the rate of equal pay in this case because it did not account for a critical measure of work performance. The court took total compensation approach, dividing the total amount the federation paid players on each team during the class period. Reparations is not the right word. Based solely on that calculation, the district court held the women's team could not establish a prima facie case. Clawing back is the right idea. I think there's a different word for it, though, in this context. But clawing back is the right idea. The problem is the federation pays the teams not only to play, but to win. No one disputes that play for both teams has a performance component. That is plain from the terms collective bargaining agreement, which provides players with appearance fees for playing and performance. So the correct measures of work in this case are both number of game played and teams performed. Let me see if I can find it real fast. Let me do a Google search because this is going to bug me if I can't figure it out. Let me see if I can find the term I'm thinking about. I won't spend too long on it, but let me see if I can figure it out. Let's see. Yeah, because a clawback is a provision in a contract, and this isn't in the contract. So I think there's a different term for it. I'm not going to spend too long on this because I don't want to eat the stream by trying to find a definition that I can't remember. Yeah, I can't find it, so we'll just have to press on. The district court failed to account for the performance component of teams' compensation. It viewed Equal Pay Act requiring the women to significantly outperform the men just to give approximately the same pay. The women's team had to win 2 World Cups and maintain an overall win rate of 83%, while the men's team did not qualify and won just 53% of its games. Would my mods please take attention to the chat? Thank you. If by district court's logic, the women would... Yeah. The flaw in district court's analysis becomes clear when considering how just one game would change the analysis. If the women had lost the World Cup final instead of being it, they would have earned an average of $206,000 per game, $6,000 less by men. By the district court's logic, the women would then file a claim for equal pay. That makes no sense. By performing total compensation without regard to performance, the district court penalized the women's team for the success. This is the problem. This is the problem with mods, and also yeah. Washington Daily, would you please attend to this issue in the chat before you worry about the definition thing, please? Thank you. Would you adjudicate that so I don't have to? Second, the district court relied on two district court decisions for its total compensation. Neither provides support. The court quoted a different case. For the proposition, a court can compare women's and men's total compensation when higher pay in one category can offset lower pay in another category. That proposition is wrong. The court in the case simply admits the fact that Equal Pay Act refers to an equal rate of pay. In any event, the quoted language is dicta. The court did not have before a situation where an employee had higher pay in one category and lower in another. The facts in the case are nothing like the facts here, where the women were paid less than men for every appearance. Yeah, and I also think it's probably unlike the facts there because of the nature of this kind of work. This nature of work is different than your average nature of work. So I think this situation begs for a different legal result because this factual working scenario is not comparable to pretty much any other working scenario you can name. This is we have a name for that in law, by the way. It's called sui generis. Yeah, this is sui generis. I think this is a new thing that we are just now experiencing. The district court's approach is also not supported by that legal term I remembered. That's nice. By Diamond. The plaintiff in Diamond, a portfolio manager and financial analyst, were offered the same compensation deal as by her male counterparts. The court did not assess whether to establish a prima facie case because the employer made out two affirmative defenses. So the decision likewise does not provide guidance on the meaning of race and pay. That district court, in effect, was using women's success against them. That was wrong as a matter of law. Under Equal Pay Act, the employer cannot make a woman outperform a man to receive the equal pay. The district court treated equal pay analysis as dispositive under Title VII. That was wrong. Title VII is broader. It prohibits any discrimination on the basis of sex, even if women and men are not doing equal work. And this is where those statements, those affirmative statements from the soccer federation could burn them. So that would be another way for the Court of Appeals to potentially resolve this problem, if it really wanted to go that way, which who knows if they do. But it could say, yeah, there's not an equal pay claim here, but there is a Title VII claim because of all the issues. So go to trial with that. So that would be another way to solve it, which also incidentally wouldn't make me as grumpy. If they wanted to go that way, it wouldn't make me as grumpy. If the Court of Appeals somehow reaches the conclusion that, yeah, there's no equal pay claim here for all the reasons that we've kind of been talking about, but these statements express an animus under Title VII, so go do a Title VII analysis, I'd be much less grumpy. Here, the women's team provides sufficient evidence to permit the jury to find Title VII. They might very well be right about that one. They might be right about the Title VII thing, so I wouldn't be as grumpy about that one. They show that women receive lower appearance fees and bonus than the men across the board, and they provide direct evidence to establish women gave those lower amounts because they're women. Maybe. I don't know whether it's subsumed or not because it's the same issue, so I don't know how that works out. Yeah, we as members, as longtime members of the channel know, we do have a general rule of be nice to each other. Our rules on the channel are stay on topic and be nice. So, and also don't use all caps because the bot will get you. The district court independently erred by dismissing the player's evidence of unequal pay. On Federation's motion for summary judgment, the court was required to view the evidence in the light most favorable to the women's team and draw inferences thereto. Couldn't the men sue for discrimination due to no base pay? Apparently. The court was not supposed to weigh disputed evidence or make credibility determinations. That's true. The court is not supposed to do that if it matters. The women's team players provide three categories of evidence. The men's team's collective bargaining agreement, which expressly show unequal rates of pay, expert testimony from economists who demonstrate the value of the pay, and statements from the Federation acknowledging that women do not receive pay because they're women. That last part is the easiest thing for the Court of Appeals to hang their hat on. The district court rejected all that evidence out of hand, but the evidence was relevant and probative, and a reasonable jury could find establishes violation of Title VII. They might be right. The equal pay arguments don't do really much for me, but the Title VII arguments, because of these statements, you could get something there. So, like, because of that evidence, you might be able to get something there. Maybe, maybe not, because you're trying to relitigate the same thing twice, but then again, you do have two different statutes, so not 100% sure how that one comes out, to be honest. If I were a betting man, though, I think that the reversal on Title VII is more likely than not. The express terms of the team's collective bargaining agreement showed the rate of pay were unequal. The women's amended agreement contained bonuses for winning and appearance. The performance bonuses make up the vast majority of compensation. Yes, they do, but as we've been kind of noting, it's not about the percentages, but the rate, right? It's about the rate, and the rates are different because not so much for the men on the base pay. For every bonus available to women and men but one, the amount of team was lower for women. There's no dispute. One of the Federation witnesses admitted his deposition. The every bonus in the women's agreement except with only one exception. The following is the bonuses, and I don't really care that much, so we'll skip that. Yeah, I don't really care that much, so we'll skip that. The first part of the Table 1 addresses friendlies. It provides ranges for wins and draw bonuses. All but one, they're lower for the women. Yeah, what would be hilarious if it went to trial the women and the jury found the men were a discriminated party. Yeah, that'd be great. How much are we doing? We're on 53 of 79, by the way. When Nate told you guys I go into a deep dive, he wasn't really kidding. We go into deep dives, baby. The third part addresses the World Cup. It listed various bonuses for winning, bonuses for qualifying, bonuses for winning, and bonus for reaching the top stages. These bonuses are cumulative. The significantly higher amount for men's performance bonuses are probative evidence of unequal pay. The Federation admits these bonuses are all undisputed and may be determined from the face of the respective agreements. By offering the women lower performance bonuses, the Federation required women to be more successful, with a higher percentage of their games and perform better. And that argument would work kind of anywhere but maybe here. That argument would work maybe anywhere but here. Because of the sui generis nature of this particular profession. This might be a one-off, or at least the start of a new thing, right? So yeah, if it were anywhere else, but I'm not sure about here. Let's see if we have any more bots chats. Hal Pike says, if the men do get paid more based on viewership, what will the metric be legally required to be included in the contract? Show the bonuses were fair. Apparently, according to the women's deal, it still wouldn't matter because they wouldn't get as much money. Like if they had the exact same structure, it still wouldn't matter because they get less money. So the exact same rate of pay doesn't mean the same structure. So it's not like percentage of the broadcasting, unless it's an equal percentage of total for both. So unless it's total amount of ticket sales for both shared by percentage, then yeah, you can't apparently choose one over the other. Matt says he's having a great evening. I wish I had more time to watch that. Matt, that's okay. This will be available for rewatch so you can get into the depths of it. And for the 104 of you who are currently watching, which is, I hope you're enjoying this and I hope you like and subscribe. Not to be too self-centered, but what the hell. I was kind of hoping for a wider audience given the interest in this on Nate's channel. So this is about average for me. So I'm very happy all the rest of you are here, of course. But I wish it was a little bit more popular. So yeah. Maybe I'll start having to compromise on that integrity thing. So just be another, common talking head that just goes to one side and just rah-rahs for that side. Yeah. That sounds good. The Harem W says, if they're new, I appreciate that. Thank you for being here. The appearance fees for women are always lower than for men. The non-contracted women are directly comparable to men because both are paid each time they appear, and then blah, 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 and the exact, but we covered that a little bit. Contracted women can also be compared to men. How? That's done by taking salary for a contracted player, adding the value of the additional benefits, and dividing that out by the number of games played. I don't know that's a fair comparison. Following table summarizes how they would have been paid. Blah, 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 blah. The court was wrong to say the agreement cannot be compared. And the court's view could not compare because of the unique aspects of the women's agreement. Rather than attempt to value those aspects, the court disregarded this is wrong. But that value was known to you, or should have been known to you at the time, right? That's one of the reasons you wanted it. You wanted the guarantee. Noli D says, you never answered. I never answered what? Hey, I invited you to come on Police Accountability Report for a Phil Turner interview we did. I did respond to your email. I was late in responding, but I did say something like, if you can arrange it, I'd be happy to. So I did respond to that email. I was admittedly late, but I'm happy to do that. So if you can arrange that, I'd be happy to do that. So yeah, let me just check my email and make sure that, because I don't want to speak out of turn. But let me just check real fast. Yeah, I think I see your email dated July 25th, and I responded to you on August 9th, which I understand is late, and I apologize for that. If you can still arrange a collab, I'm happy to do it, and I'm sorry for the late reply. That's totally my fault. And if that opportunity is gone because I didn't respond, then that's my fault, and I respect you for trying to arrange it. Yeah, that was my bad. I'm sorry. I since set up the account so I'll be able to get the emails in my direct inbox. So, yeah. Curtis Handsome, well, thank you very much. It's very, very kind of you. Oh, man, I'm getting a little bit tired. Just for my brain's getting a little tired, so I'm getting a little bit foggy. But we'll try to press on. Or I'll have a drink and see if that helps. There is an optimum amount of alcohol where you're like in the zone. In fact, what the hell? Let's have a little bit of bourbon. So yeah, people know occasionally that we do some bourbon with the streaming. So we're going to do some bourbon with the streaming and have a little bourbon and see if that improves my mood. So hold on, I'll be right back. Talk amongst yourselves. And we're back. Cheers to everyone. 4 Roses Small Batch is really, really good. In fact, it's my favorite, 4 Roses Small Batch. That's tasty. Bourbon is tasty. It was a great invention America gave to the world. All right. Snap to it. As an initial matter, it's the jury's job, not the court's job on summary judgment, to evaluate the evidence and determine whether the women received unequal pay. The jury would have ample basis to do that using the agreements themselves and experts' report that valued the compensation under those agreements. A district court cannot reject evidence of pay discrimination out of hand because of differences in compensation systems. Well, yeah, the question here is, what is the legally relevant evidence? So it can, under the court's theory, which I think is fundamentally right, So it makes sense to me, but you could see the Court of Appeals very easily disagreeing with us, either under equal pay or under Title VII, which would kind of be a nice way to have your cake and eat it too, really. If you said that under equal pay, this isn't comparable because of all the reasons and so forth and so on, and then said because of the statement specifically, though, Title VII is at issue, so go adjudicate over that, that'd be a really nice way to have your cake and eat it too. And probably is the legally correct result, although it's questionable because, as I mentioned a couple times at this point, the Title VII is broader, but you're kind of dealing with the same issue twice, but then again, it's two statutes, but then again, you have the exact statements of animus. So, that'd be a way to have your cake and eat it too if you're in the Ninth Circuit and so inclined. Or the Supreme Court and so inclined. If that were the law, any employer could create a slightly different compensation scheme for women and men and avoid all scrutiny under the Equal Pay Act. Yeah, this is a unique world. Yeah. We're drinking Wild Turkey, by the way, tonight, in case you wanted to know. It's a very nice it's a very nice base liquor. If you're getting into it. That and Buffalo Trace are good recommendations for first timers. Probably Buffalo Trace because it's not quite as alcoholic. Still going? Damn, 50 pages. Well, technically we're on page 59 and 79, but yeah, because there's a whole lot of preliminaries and tables of contents and blah, blah, blah. Furthermore, the district court was wrong to assume the fact finder could not value the various components of the women's agreement. Both the women's expert and federation expert valued the player salaries and benefits based on how much it cost the federation. That's an accepted way to value, which seems fair enough. In the analysis, the district court actually did value those benefits. The district court used total compensation for women, including the value of player salaries, maternity leave, and severance. The court got that amount from the federation's accounting expert. So it's certainly possible to compare the value of the men's and women's agreement. The district court erred by not giving the jury the reason to do so. I guess the idea is if I had taken your expert, I still would have come out the same way because it wasn't based on that factor. But yeah, so there's something there. The district court also suggested that women choose their deal over the men's deal. It speculated women were willing to forego higher bonuses in exchange for having guaranteed salaries, which seems right, which the court viewed as a type of insurance. Yeah, but the women were never offered the same deal as the men with the same level of bonuses. Furthermore, there's no player salary guaranteed. Any player could be cut from any time. Yeah, but there are a guaranteed number of positions. So while any player might not benefit, a fixed number of players would benefit. So, yeah. And even if the salaries had some intangible insurance value, a jury could determine that value. That's kind of fair. Finally, in comparing the value of the women's and men's agreements, the jury could also consider the fact the Federation refused to offer the women and men the same deal. During the negotiation, the Federation offered the women the same pay-to-play structure without salaries, but all the women bonus numbers were lower than the men's bonus numbers because the economics were not the same. What they should have done probably is expressed it in percentages of some kind of revenue. And then the numbers would have... So the numbers were certainly calculated by percentage of some kind of revenue, because what else would you calculate them on? So rather than come to the end conclusion of the dollar amount, the better way to draft this contract in retrospect would have been done to do it by a percentage. So like say, okay, it's X percent of ticket sales or X percent of this or X percent of that, right? And list the percentages rather than dollar values. I mean, if it's zero, you can list zero. But otherwise, you list it as percentages because presumably that's how you calculate it. Or if not, in the first instance, you convert it based on current economic conditions. And if you get a little bit more money in, the women wind up a little better off. And if they don't get as much money in, they're worse off. So it's actually kind of nice for you as the employer because you're tying it to your revenue. So if the women do better and bring in more revenue, everyone benefits. And if they don't, everyone loses. So that would have been the better way to... Then you could have looked at the contract side by side, right? You could have looked at the contract side by side and say, oh, they're literally the same. Even though the thing they're being based off isn't the same, but at least on paper it looks the same, right? So it's a better argument for the men. Investigator says, I like this comment. I'm used to Natalie style. We all come in and take off our shoes, get comfortable, drink, and settle in. This is more like being in court. Damn right, ma'am. This, or more to the point, this is a little bit more like being in law school. I am by far and away the the YouTube professor or YouTube commentator who's the closest to law school. Now, you wouldn't go through it in this level of depth in law school. You would do things shorter, and you pick different things. You wouldn't do this, but it's the same fundamental experience in a lot of ways. So basically, it's like law school, kind of, sort of. So it's the closest experience to it. So, you know, unfortunately, I'm not accredited. So I really, really enjoyed our talk with Natalie. I don't think I'm trying to think for sure, but other than the video that I augmented my opinion based on, I think I might have seen one other video for her. For whatever reason, although I watch a lot of legal videos, she's just not in my feed. I couldn't speak to why, but I'm not familiar with her content. So I went in with no particular expectations. I had a really, really good time. She was very fun to talk to. Yeah. Sometimes super serious, and then he has ones where he's goofing around. That's true, too. Finally, in comparing the value of the women's and men's agreements, the jury also considered the fact the Federation refused to offer women and men the same deal. During the negotiation, the Federation offered the women the same pay-to-play structure, but all the women bonus numbers were men. By the way, if you're wondering why, also, okay, so this is also a good exemplar. This is a good exemplar of why on my chat or why in my streams I sometimes repeat myself. Like, why is Uncivil Law repeating himself? Because I'm used to reading legal filings. And legal filings can be kind of repetitive, as we're seeing. For the 5th, 6th, 7th time, it's coming up. It's like, why is Uncivil Law saying the same thing? Because I think in legal filings, I guess, is the answer to that question. Yeah, Natalie is relatable. She's very relatable. She has a good personality. She reminds me of Emily in some ways in terms of like just being a very welcoming person. They're very different in the way they're welcoming, but it's the closest comparison I can think of off the top of my head. Also, she said that she'd be watching this video. Has anyone at any point seen Natalie the lawyer chick in this chat, just out of raw curiosity? Has anyone seen Natalie the lawyer chick in this chat? Because when I got off the phone with her, or whatever, when I got off the stream with her, I said, hey, don't forget, I have a stream coming in 10 minutes. She said, I'll be there with my salad. Just out of raw curiosity. Has anyone seen her? Either way, she's awesome. The women's team present evidence from their expert, Dr. Cook. She demonstrated the rate of pay was much less than the men pay, blah, blah, blah. Dr. Cook demonstrated blah, 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 blah. Dr. Cook determined if the 4 class representatives had been paid under the men's agreement, they each would have received an average of $2.5 million more over the class period, and the class as a whole would have received $64 million over the period. From that analysis, a reasonable jury could conclude the women's pay was worse than men. The district court, the district court apparently believed that since the agreement was a result of collective bargaining, the players could not argue their pay was unequal. The court called Court's expert analysis untenable because the men and women bargained for different agreements which reflect different preferences. By the way, just for the record, in case I should just make this point clear. This is well written. This is well written. It's well written by a competent attorney. Maybe a little bit less on the repetition, but other than that, that's a stylistic choice. But then again, you want to make sure it gets through the judge's thick skulls. So there is that. So fair enough. But this is well written by a competent attorney who is doing a very good job representing their client. So regardless of what we think about the underlying issues, I think we can all appreciate and validate that this is a good attorney's work. It's good. It's very good. So, there's that. The Equal Pay Act contains no exception for pay discrimination in collective bargaining. The Act prohibits unequal pay for equal work subject to only 4 conditions. But the thing is, it contains no exception for pay discrimination in an agreement, but they're 2 agreements, right? So they're 2 different unions. And that's not completely unheard of in different workplaces. depending on the type of workplaces. There could be different unions for different kinds of work. So even in the same workplace, depending on the job roles, it wouldn't be unheard of for there to be more than one union. And those unions obviously negotiate for different things and come to different agreements. So there can't be any discrimination within the agreements, but as between agreements, it's like, oh, their men are getting paid more than our men or whatever, blah, blah, blah. Yeah, I don't think about that. She may be watching on her TV with a hubby he's lured to. Well, in that case, if she's watching on her TV with her hubby, I just want to say I had a fantastic time. And I hope to talk to you more and perhaps your hubby more. More lawyers in my network is great. And I hope you're enjoying this content either way. So I'm glad I can be a benefit and augment your evening in some way. That's cool. The Equal Pay Act contains no exception for collective bargaining. It only contains these 4 exceptions. EEOC guidance confirms the point. The establishment by collective bargaining of unequal pay does not constitute a defense. If it's within the same agreement, yeah. But if it's between agreements, no. And as I said, there are situations where that happens. The Legislative Act of Equal Pay reflects that understanding. The act was needed because collective bargaining had not proven adequate to eliminate pay. Fair. And it's also fair just as a matter of basic contract law, right? We've all established this many times, right? So to the extent, right, contracts can't contain provisions for illegal things. And if they do contain illegal things, they're void. So yeah, the federal government has said, okay, essentially in so many words, your contract can't include this provision. It's void as a matter of law. So, it's modification of contract law. So, fair enough, or at least that's one way to view it. Actually, I don't know that any lawyer has ever viewed it that way, but it would be a way to view it. You could view it in contract law terms if you wanted to. Is there another pay method? Yes, there is on PayPal. And also the bot should periodically be giving you the Streamlabs link. So, yeah. Similarly, Title VII does not exempt pay discrimination. Okay, we covered that. Employers, therefore, cannot shield discrimination from legal scrutiny by getting their employers to agree. That makes sense because every employee has been discriminated, has agreed to his salary. That's fair enough. That's a fair point. You can't discriminate on an individual basis because they agreed, and you can't discriminate on a collective basis because they collectively agree. Very, very fair. The district court also dismissed expert testimony because it believed the players rejected the terms they now seek to retroactively impose. To some degree, yeah. It depends how the Ninth Circuit parses this. And the district court's opinion could have made points slightly clearer that would have helped. So it depends a lot on, it's hard. It's really hard to predict what the Court of Appeals is going to do on this one. It's really hard to predict. I can tell you what I think should happen. And in my opinion, kind of at the moment is, or at least my tentative opinion. Well, one is, my not so tentative opinion is the equal pay claim doesn't make sense. My more tentative opinion is the Title VII claim does make sense. So my sort of overall tentative opinion is, if I were a judge, I'd be inclined to affirm on the equal pay and reverse on the Title VII. So, and it's the Ninth Circuit, which is as a mixed bag as you can get. So, the Ninth Circuit has more Republican judges than it ever has. So it's not quite as bad as it was in the bad old days. So, you could always get lucky or unlucky depending on your perspective. The Federation acknowledged all the bonuses in its pay-to-play offer were lower than the men's. It should have probably stated it as percentages. The district court did not find it contrary. It stated only that the women's team rejected an offer to pay under the same structure. At no point did the Federation offer the same agreement with the same terms. Yeah, that's probably why it should have done this in percentages. Would have been better. As a result, equal pay was never on the table, and the union agreed to the best deal that could be negotiated. So you're not throwing the union under the bus anymore? I don't think this will go on bonk if I had to bet. That seems unlikely. More likely, Supreme Court seems possible. Unless, of course, the panel affirms for the court. Unless, of course, the three. So if they reverse, I don't think it goes on bonk. If they affirm, the odds of on bonk go up. So yeah. And my ever-present hope that the Supreme Court yeets it out of the Court of Appeals is always on hope. Okay, they've admitted their discrimination. They repeatedly acknowledge they pay. They made their opinion clear again and again. They never authorize paying the same bonuses because they literally can't afford it. The equality because of genetics, biology. Genetics and biology are in fact a thing. Maybe God is discriminating on the basis of sex. So, sue God. During negotiations for women, Federation Council stated that market realities are such women do not deserve pay. Again, the word deserve was an ill-advised choice here. Reasonable jury could just take the Federation at its word. Yeah. The district court erred in creating the version of events. The court credited the after-the-fact explanation. The court dismissed the statement about market realities, which, I think is valid. God is, in fact, not suable. That's true. Yeah, he's not suable. So, yeah. People have tried, and they've tried suing Satan, which is hilarious. The problem is we don't know where to give them service. And what address is God or the devil located so we can give them effective service? Who's going to sign for that one? Yeah, I don't know if there's a movie about a man suing God, but it's definitely happened in reality a couple times. Never successfully, of course. Okay, so reverse and then attachment. So we're finally done. So, yeah. So then, yeah, let's just read the actual statutes because we got the shortened version. So we got Part B, which speaks to labor unions. No labor organizations or its agents representing employees having employees subject to any provisions shall cause or attempt to cause the employer to discriminate. So, yeah, that Section 2 specifically, by its own explicit terms, takes power away from the labor union to do this if Part 1 wasn't sufficient. And then it says no employer having employees subject to any provision of this section shall discriminate within any establishment, again, establishment, right, in which such employees are employed between employees on the basis of sex by paying wages to employees in such establishment. Is this an establishment? At a rate less than the rate at which he pays rate to employees of the opposite sex in such establishment for equal work on jobs of the performance of which require equal skill, effort, and responsibility, and which are performed under similar working conditions. There's a lot of language here. There's a lot of language here that opens up the possibility of the court agreeing with the district court, right? There's any number of words that would allow you to say this doesn't apply. These words would include such things as establishment, equal work on jobs, equal skill, equal effort, equal responsibility. There's a lot of things here that distinguish them. And then you have the explicit ones, except where it's made pursuant to a seniority, which doesn't apply, a merit system, a system which measures earnings by quantity equality or any other basis other than sex, such as, economics. That provided the employer who's paying a wage differential in violation of the subsection shall not, in order to comply, reduce the wage rate of any employee. Okay, well, I'm not sure how that. Okay, so you can't level down, I guess. So fine. And then we have Title IX. Shall be unlawful for an employer to fail to refuse to hire or discharge any individual under or discriminate for compensation terms, conditions of employment based on race, color, sex, or national origin. Unlawful employment is established where complaining party demonstrates that race, color, religion, sex, or national origin was a motivating factor, even though other factors motivated, because it's still a discrimination on those bases, even if other factors are present. And then we have a definition of wages and wage rate and blah, 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 and certificate of service, and we're done. So that took us 2 hours. That's how we roll here on Uncivil Law. We roll here deep on the Uncivil Law. We do deep dive analysis. Genome editor, you are late because we are wrapping up. That's how late you are. We are wrapping up. We've been here 2 hours, Genome editor. We are done and we're wrapping up the stream. So yeah, I'll just kind of conclude with my overall thoughts. I can see the basis for the Court of Appeals to reverse on equal pay. I'd be dishonest in saying I can't. There's enough meat here for the Court of Appeals to gnaw on if they want. And there is better than that in the Title VII. So, my personal inclination at this point, if I were a Court of Appeals judge, and I might have screwed it up the same as the district court judge for that matter, but as a Court of Appeals judge, reading the arguments and being better and well informed, right? As a Court of Appeals judge, my initial inclination would be to affirm on the equal pay claims and reverse on the Title VII. Because there's enough there so I can kind of have it both ways. And also there's more than enough there, to be quite honest, for the Title VII in terms of the overt statements. So, there's that. And then I might want to consider to the degree to which the overlap of claims of causes of actions should be a problem, which I'm not sure it is, to be quite honest, because they're different statutes. And you can have causes of action under more than one statute. So the fact that your equal pay claim is no good doesn't necessarily mean that you can't make an equal pay argument under Title VII. It's just a different cause of action. So, yeah, I think they might very well be able to get there under Title VII if I were, and there's more than enough here for the Court of Appeals to reverse on if they're inclined. So, yeah, we'll see. It's well written, well briefed, well argued. They have enough here to go on if they want to. So, that's what we think. Provolone Leaf says it got you through your workout. Wow. Okay. Yeah, so. All right. Yeah, I'll text you back. I'll email you back down. No leave. Probably tomorrow because I'm beat as shit. So I'm gonna have some food and I'm probably gonna crash. I did do an entire live stream before this, so there is that. If you're enjoying this legal education content, may I be so kind as to please ask you to hit the subscribe button. It would help me grow and achieve my dreams and let me seen by more people and, make this all worthwhile so I don't have to sell out myself to the algorithm gods and just be, a complete right-wing Republican shill and yet just completely own the libtards at every possible opportunity, no matter what the legal analysis really would require. But, so I don't have to go down that road because I don't particularly enjoy it. If you could subscribe, that's great. And if not, then I'll have to sell out and that'll be annoying. Question C gave me $200. That is an incredibly generous super chat, Question C. Thank you very, very much. Fan of yours since the beginning. Focus on content, not numbers. The only one making videos that'll be worth watching 20 years from now. Well, Question C, that is an incredibly, incredibly generous super chat. I can't thank you enough for your note of generosity, and I appreciate it. I like to think that I'm providing some value here in terms of stuff that's good education. So we're all more well-informed of the law, but for better or worse. But $200 is an incredibly, incredibly generous super chat. Thank you so much for that, Question C. That is just awesome. Yeah. You care on Uncivil, but get more views if videos were easier to understand with a long background. Yeah, I agree. I am not good. I am good at some things and not good at other things. I am not really great on coming up with the clickbait titles. I am not great at coming up with good thumbnails. I've tried Fiverr, incidentally, and the thumbnails that I've gotten so far have been disappointing in their quality. So I don't know what I'm paying for. But yeah, I understand in principle. It's just I don't know how to do that in practice. I see other people's titles. I'm like, that's really good. I don't know how to do that myself, though. So yeah, I don't know how to do that. So, maybe I need an editor. What I need maybe is an editor whose sole job in life is to come up with creative titles, creative thumbnails, and better descriptions. So if you're interested in this position, which offers absolutely no pay of any kind, but if you're interested in this position to help me out on that, contact me on Discord or contact me on email. It's uncivillawYT@gmail.com. I need to put that in the description. And let me know that you want to help with the titles and the thumbnails or the descriptions or any part there too. And I'll be happy to have you because I obviously suck at those parts. So yeah. I suck at those parts. Good on the law. Good on the law, not so great on the editing, titling, descriptions, thumbnails. Not so great on those YouTube skills. Yeah, some internet marketing. I don't know where to go. It's like I am. So I'm going to sign off for now so that I can finish this bourbon and I completely crash out hard and probably not wake up till 1 o'clock tomorrow. That sounds great. In terms of everything, I hope all's well, my friends. Cheers and goodbye.